Hello viewers, Major General Neelendra Kumar in conversation with the Senior Advocate V. Sudhesh Pai from Bengaluru, the author of this famous book, Legends in Law. The third person that I would seek focus and light from you is one Mr. J.D. Mayne, who was an Englishman and a very competent practitioner of law, and it is said that his book on Hindu law, mind you, a Britisher writing on Hindu law, and that book almost decades later or a century later was quoted by Justice Hidayatullah and Mr. Kanhaiyalal Maniklal Munshi. So that goes for the eminence and the reputation of the book, the value that it had. Would you like to talk something about J.D. Mayne?
J.D. Mayne was one of the earliest practitioners in the Madras High Court. The Madras High Court, as you know, is the third oldest High Court. The Calcutta High Court in July 1861, the Bombay High Court and the Madras High Court in August 1861. So just a few weeks apart from one another. And Mayne was one of those earliest practitioners there. He was not just an advocate, but a scholar in the true sense. The book that you referred to and quoted is not Hindu law. The man was good in every field of law. He wrote a commentary on the penal code.
On the Indian Penal Code, on the law of crime,
which has just been enacted then. You know, Macaulay's, because Mayne left India in the 1870s.
Yes.
He was born in 1830.
So, 40 years he was in India.
Yeah, 40 years, of which the first 20 years you can give a go by. So, he was there when the court came. And he wrote a classic book on damages.
On damage, law relating to damages.
He wrote on the Indian Penal Code. And he wrote, of course, on Hindu law. And that is what is absolutely remarkable. Here was an Englishman. He didn't write from secondary sources. He studied Sanskrit.
Look at this.
Read the original texts. Took 15 to 20 years to write his book, Mayne's Hindu Law and Usage, which has undergone many editions, is even today, more than 150 years later, referred, studied, quoted as absolutely authoritative. Extremely great people have edited it after him. Englishman, Chief Justice
Hidayatullah.
Chief Justice British. Chief Justice Cute Trotter of the Madras High Court, Srinivas Iyengar, much later other people. There have been so many editions and it still stands as a classic.
And this is remarkable that an Englishman picking up Sanskrit and acquiring the competence in Sanskrit to read Hindi, Sanskrit scriptures and coming up with a commentary. Yes.
And talking of the book that you mentioned was quoted by Hidayatullah and Munshi. That's the book on crimes, the penal code. Arguing in the Nagpur High Court before Chief Justice Frederick Grill, Munshi quoted a passage from Mayne, and it's considered authoritative. No one has ever doubted its authority. Hidayatullah as Advocate General appearing for the defense, appearing on the opposite side, interrupted to say that that may not be the accurate position of law. Both Munshi and the Chief Justice felt a little surprised and also aghast as to how Hidayatullah could say that what was cited as Mayne's observations, Mayne's authority, did not state the accurate position. Munshi was absolutely flabbergasted. The Chief Justice also felt uncomfortable and said, Mr. Advocate General, but how do you say that? What's your authority? And Hidayatullah quietly replied, John Mayne himself, in a later edition.
has clarified
Yeah,
and sort of
yes. I mean,
took a position.
yeah.
That's remarkable that the people kept track of changes that came about in the later editions. That they were changes and they were readers who took note of that.
Yes,
Both
yes.
are remarkable.
And Mayne also has the distinction, the Indian Law Report series,
Yes.
ILR Madras, page 1, is a case argued by Mayne.
Okay.
Of course, incidentally, it's not a case in the Madras High Court, it was a case in the Privy Council. Because after leaving Madras, as I said, sometime in the 1870s, he settled in England and appeared before the Privy Council in the many cases that came from India.
Thanks. Now we come to the next eminent person who's been included in this book, and that is Mr. T. Muthuswamy Iyer. And of him it has been said, it may appear as a trivia, that he always walked into the court barefoot, and he was appointed a judge of the Madras High Court, 1878. And he is especially praised, remembered for the precision and decisiveness in his judgments. Would you like to highlight some salient points about this?
Muthuswamy Iyer, of course, is the first Indian judge of the Madras High Court. Whitley Stokes, in his Anglo-Indian courts, observed that no judgment is as, this may not be the exact words, but the idea, I've quoted it somewhere, no judgment of any judge is as remarkable as that of the Hindu Muthuswamy Iyer and the Mohammedan Said Mahmud in Allahabad. And it is said that, I think it was Muthuswamy Iyer who went to see Mahmud in Allahabad, traveling all the way from Madras to met, because each one recognized the greatness of the other. And Muthuswamy Iyer rose from very humble beginnings, absolute, one could say, poverty, and then rose to great heights step by step, and I think he was a district judge, appointed as the first High Court, Indian judge of the High Court. And he was so thorough in his knowledge. He would teach the Englishmen the Roman law. Companion judges sitting with him, he would quote the principle and the quotation.
Guide them and sort of show them the...
And pronounce the Latin phrases correctly for the Englishmen. And this was the kind of man. And of course, as you said, he entered the court barefooted, and with nothing there you could see his bare feet. And Norton says that when an argument was going on, one toe would get on the other toe, and then you know what the fate of your case is.
People must have deciphered and attached meaning to it after years of study.
And he was, of course, as Norton, early Norton, of course, one of a very great lawyers, says that Muthuswamy Iyer was like a brake horse to which every new judicial court was harnessed. He was the trainer.
Very well put. And
there is also a humorous
incident attached to it.
There was a special bench constituted by the Chief Justice, Muthuswamy Iyer presiding. Big case that was to go on, expected to go on for weeks. Norton was for the appellant, and as soon as the bench assembled, he got up and said, "I'm sorry, my lords, the case cannot go on, the appellant is dead." Muthuswamy Iyer got a little irritated, saying, "Oh, we have prepared ourselves, the case is a heavy case, this bench is specially constituted for that." But then, this is beyond anyone's Norton
capacity.
Norton very mischievously said, "I understand, my lord, that appellant did not have the courtesy to inform me before he died. Otherwise, I would have told your lordships not to get ready."
That is wonderful. Very, very nicely and humorously put it. And thanks. With that, we move to the next person, and that is Sir S. Subramania Iyer. He is a person, it was said of him, that he had knowledge not only of Indian and English law, but also of the laws in United States and the civil law. Now, and he's the one who started his practice at Madurai and later shifted to Madras. would you like to
Yes,
give
yeah.
some benefit to the my
Viewers.
viewers here about the facts of this gentleman?
Subramania Iyer was the natural choice to succeed Muthuswamy Iyer when Muthuswamy died in office in 1895. And Subramania Iyer was the natural choice, both by the dint of his merit, efficiency and erudition. He was truly learned. It is said that every Saturday he would have a group of people to discuss developments in the law.
Okay.
The recent cases. Students also could attend, but essentially lawyers, but students were also welcome, and they would discuss the judgments. Subramania Iyer was known for his precision. In fact, there's one sentence in which he captured what many years later Chief Justice Hidayatullah in 1968 Supreme Court in the famous Nair Service Society case said. Subramania Iyer captured it in 1901 sentence.
Okay.
That a party ousted by a person who has no better right is, with reference to the person so ousting, entitled to recover by virtue of the possession he had held before the ouster, even though that possession was without title. What we call possessory title.
Yes.
In 68 Supreme Court, the
Was,
Supreme Court wrote very lengthy.
Subramania Iyer and credit he gave to.
Yeah, and it was put in one
yes.
sentence.
Yes.
And Subramania Iyer is perhaps the first Indian judge to have referred to American precedents.
Okay.
If I may digress here for a moment,
Yes.
and coming back
To
many years
yes.
later, when Chief Justice Venkatachalaya visited America, the then Chief Justice of the American Supreme Court, William Rehnquist,
Yes.
had the, if I may use the expression, foolishness.
Okay.
He presented a book of the American law reports to the Indian Chief Justice and said, someday it may come of some use. Venkatachalaya told him,
very unwise.
Venkatachalaya told him to his face, I did not know that the American Chief Justice was so ignorant.
Yes. He told him on his face. Yes.
We have been using referring to American reports for wrong. Then I pointed out to Justice Venkatachalaya before Rehnquist was born.
Yes.
William Rehnquist was born in 1924.
Okay.
Subramania Iyer has been
that,
a judge from 1895. And the second judge was Ashutosh Mukherjee, who died in 1924.
Yes.
So both Ashutosh Mukherjee and Subramania Iyer were profusely referring to American precedents, not just to the American Supreme Court, but even of the state courts.
Okay.
And so that gives the standard, the measure of William Rehnquist,
Yes.
the Chief Justice of the United States. I mean, that's aside.
Yes. Thank you. Stay with us. This conversation will continue.